Welcome, everyone. Thank you for joining us for the webcast, Wage and Hour Litigation on the Rise, Tips for Avoiding Class Action Lawsuits in 2017. This webcast is sponsored by EPAY Systems. Before we begin, I would like to remind you that this webcast has been approved for HRCI and SHRM recertification credits. Please be sure to attend the complete webcast in order to receive your credits. After the webcast, you will receive an email from HR.com within 1 to 2 business days. It will include your certification credit information. If you have any questions today for our presenters or for HR.com, please type them into the Questions tab on your GoToWebinar control panel, and we will follow up with you. And now it's my pleasure to turn it over to our first presenter, Michelle Lanter-Smith.
Good day, everyone. Again, my name is Michelle Lanter-Smith, and I'm the Chief Marketing Officer here at EPAY Systems. And I'd like to express a warm welcome to all of you on the line. We have almost 400 people with us today, and we really appreciate you taking this next 90 minutes to dig into a little deeper into some of the compliance issues that are happening to firms across America. We're very, very fortunate to have with us two special guests from Seyfarth and another special guest from EPAY to help us get through this information, to understand it better, and really see what we can do to address compliance issues. So let me do some quick introductions, if I may, and then we'll very quickly move to the content of today's discussion. Today with me is two very, very skilled lawyers from Seyfarth, a partner of ours that we've worked with for the last 4 years to bring our customers and folks in our community information like this to help them really manage their business, control compliance. The first person I'd like to introduce is Kevin Young. Welcome, Kevin. Kevin is a partner in the Seyfarth Labor and Employment Department and a member of the Wage and Hour Litigation Practice Group. His practice includes defending employers in class and collective action lawsuits, representing clients facing agency investigations, and providing preventative counseling on a range of employment issues with an emphasis on wage and hour compliance. Welcome, Kevin. Also with us today is Kara Goodwin. Kara is a member of Seyfarth's Labor and Employment Department and Wage and Hour Litigation Practice also, where she focuses a significant portion of her practice on representing employers across the U.S. in the defense of complex wage and hour claims arising under federal and state laws. Kara also provides preventative counseling and works with employers to minimize their exposure to investigation and litigation under the Fair Labor Standards Act in state and our laws. And then also with us today is Jay Callender. He is our Chief Operating Officer here at EPAY Systems. And Jay is responsible for influencing the development and overseeing the implementation of all of EPAY Systems technologies. He brings 20+ years of experience in operations management, systems development, and strategic integration. And he absolutely understands the distributed workforce environment, the hourly workforce environment, and many other complex environments, and what that means and how that plays a role in compliance, and also in how you can really use time and labor management information to get to the root cause of why things happen, what's going on, and how you can better control and make sure you're in compliance. So welcome to all of you for joining us. Thank you very much. I just want to talk a little bit about what we're going to cover today. We're going to go through an FLSA overview. I'm going to turn it over to Seyfarth to do that. And they're going to talk about really why are we seeing so many of these cases? Why are they so popular? And some of the possible new exemption rules, what to look out for. And then navigating these waters, navigating how to get through it. And then we're going to turn it over to Jay, and he's going to tell you a little bit about some cases where he's helped with clients and what he typically has seen and how we address it, some of the products we have at EPAY that really can make a difference in helping you control compliance and, like I said, get to the root cause so you can control it going on into the future. First, let me just tell you a little bit about EPAY Systems. Again, we're a Chicago-based tech firm. We were founded in 2001, and we provide a completely unified human capital management solution, from applicant tracking and recruiting, onboarding, HR, benefit admin, time and labor management, payroll, and performance management. We have more than 75,000 work sites across the nation using our systems to help them track employees, manage those employees, and pay those employees, and look back and actually understand and audit and see what's happening to continue to control, to improve operational efficiency. At the heart of our system is a very robust time and labor management system. We believe, and many of our clients, such as the ones you see on the screen, believe it's a uniquely flexible system in the cloud that really allows us to communicate out to the sites easily, with easy setup, the ability to collect information under difficult payroll situations, very flexible there, and then the flexibility in reporting and analytics so you can see what's happening and going on. One thing that makes us different and why customers love to work with EPAY is that our support is 24/7, every day, and all customers get this, not just a few, not just the premium, everybody. And because of that, we boast a 99% customer retention rate. So that's a little bit about EPAY and who we are. I'm sure you really would like to move on to talk about really the compliance issues that Seyfarth is seeing and also what we're seeing here at EPAY. So I'm going to turn this over to Kevin and Kara where they can begin their presentation. Thank you.
Michelle, thank you so much for that warm introduction. We're so excited to join you and Jay and almost 400 of you today to talk about an issue that has really been keeping us busy and our clients up at night, which is compliance with wage and hour laws, particularly under the Federal Fair Labor Standards Act. Before we go into that, we wouldn't be doing our job as attorneys if we didn't give a legal disclaimer up front. Certainly what we talk about today is not to be construed as legal advice. Instead, what we hope is that our practical insights and high-level observations will be helpful to you in making sense of what's been going on with overtime and minimum wage laws, and in thinking about how to confront issues as they come up in your particular work environment. Certainly, we'll have an opportunity to take questions. If we were in person, I would have everybody repeat after me the words hypothetically speaking. We like questions that start that way rather than questions that would be seen as seeking specific legal advice on an existing situation. Also afterwards, we'll have our contact information. If there's any questions that we don't get to or that you don't feel comfortable asking, you can certainly feel free to get in touch with Kara and I afterwards as well. So we can go to the next slide. So we want to give a brief overview of the FLSA. Certainly we're aware of the types of folks who are in this audience, which would be folks who have not just heard of the FLSA, but who have experienced it in everyday practice. We know that you're familiar with this law, but nevertheless, I do think that starting with the basics, even when the basics are already known, is usually a nice way to go into this topic. So we'll go to the next slide if that's okay. So a brief overview of this area of the law. This area of the law, the FLSA in particular, was enacted in 1938. It is Depression-era legislation. It was part of the New Deal. And it was created at a time, it's important to keep this in mind, created at a time when it was factory-type jobs and jobs in the Great Depression that folks were working for pennies and being worked tons and tons of hours. And the law was seen as a way to do two things. Number one, certainly to increase pay for workers who had been oppressed or abused or what have you. In addition, what a lot of folks overlook sometimes is that it was seen as a way to create more jobs. That if employers couldn't work somebody who was just desperate for any money that they could get, if they couldn't work them 60 or 70 hours without having to pay a premium for it, then maybe they'd hire two people who could work 30 or 35, something like that. At its core, the FLSA is a pretty basic law, even though it is subject to so much litigation and so many issues. it's pretty basic in the sense that there are 3 real requirements to this law. There's a minimum wage, which is currently set at $7.25 per hour. There's a requirement of overtime pay at time and a half the regular rate of pay for work in excess of 40 hours within a work week. And in addition, there are child labor requirements that don't come up as often anymore, but they're still good to be aware of if you're in an environment where you're employing individuals who are 18 or younger, especially in jobs that require late hours or hazardous type jobs, working with heavy machinery, knives, things like that. One thing that you are all no doubt aware of is that in addition to the federal law in this area, there are also state law requirements that can be more restrictive than what the FLSA requires. And not just that, but increasingly in today's day and age, there are local requirements that can be more burdensome on employers and more favorable to employees than what the FLSA requires. Most folks know, for example, and you're probably all saying to yourself, California. Everyone knows California is a place where, if the federal law says that you must do this for employees, California typically is going to say you have to do a little bit more. And New York is one of those places too. In both of those areas, you have a higher minimum wage at $7.25, and you have other types of laws that are more favorable to employees. But one thing that is important to keep in mind is that sort of trend that kind of starts in California and New York is certainly making its way elsewhere. A lot of folks would be surprised to know, for example, that Birmingham, Alabama, of all places, recently enacted a citywide minimum wage that's higher than what the Fed requires. And I offer that not to say that you need to be aware of Birmingham, but more to say that it illustrates a point that there's more and more going on at the local level that makes it more important than ever to be tracking not just what's going on at the federal level, but also at the state and local level as well, wherever you have operations and where you have employees. Two of the most important questions for minimum wage and overtime, the 2 core requirements for the FLSA, are number 1, who might be exempt from those requirements, and therefore it doesn't need to be paid overtime if they work over 40 hours per week. And also for folks who are subject to the law, for folks who are non-exempt and need to be paid overtime when they work over 40, what counts as hours worked? Again, you go back to the fact that this law started as Depression-era legislation. The workplace nowadays couldn't look any more different. The law did not contemplate working from home and on your cell phone and on the road to the extent that folks can do so today and from hotel rooms and things like that. But nevertheless, figuring out in today's day and age what actually counts as hours worked is absolutely critical. We'll address all of these points today, at least on the surface, but one thing that's really important to keep in mind is that these points and issues under the FLSA are almost categorically construed in favor of your employees. Generally speaking, if there's a basis to say that they might not be exempt and need to be paid overtime, then it's going to be the safest path to pay them overtime. And generally speaking, if there's a path to say that something they're doing could be or should be construed as hours worked, then typically it should be. We'll go to the next slide if that's okay.
So out of this general FLSA framework that Kevin just described, there are several sort of large topics or types of claims that we see more often litigated. Those are the off-the-clock issues, regular rate issues, and misclassification issues. For off-the-clock issues, these are the hourly or non-exempt employees who claim that they were not paid for all the time that they worked. These off-the-clock claims come up in a variety of contexts. You'll have, the office employee who comes to work and claims that he or she spends a significant amount of time logging in to the computer, booting up, opening up programs, things that are necessary to perform work, and essentially getting ready to perform work for the day before their scheduled shift or before they clock in. We see that a lot at call centers, but it's not uncommon to also see it in other office settings. This off-the-clock issues would also cover employees who, quote unquote, volunteers to come in early or stay late to get the job done. We see this a lot with employees who maybe are strong performers, who want to go out of their way to do good work for their employer, but maybe just can't get all of their work done or all of their expectations met within the 40 hours that they may be required or budgeted. And this isn't uncommon. this happens a lot where, employees may not consider, they just think that they're getting their work done. They don't consider the potential implications or liability that is exposing the company to. Off-the-clock issues also cover work from home. As Kevin said, we're seeing more and more issues arise as employees, non-exempt employees, are able to use their cell phones or other portable devices or mobile devices and have alternative work arrangements where they can perform some of their work at the office, at home, or on the road, or if they travel. Off-the-clock issues also cover meal and rest periods, and these are issues that we're going to cover a little bit more detail when we talk about some common mistakes that we see. Another big bucket of issues that we see is our regular rate issues. This is where an employee feels like they may not be paid the proper amount of overtime, or that the calculation of the overtime premium itself was wrong. For example, an employee who works 45 hours but doesn't get time and a half overtime premium for those 5 hours, they only get paid their straight time regular rate for all their hours. That's going to be a problem. Or an employer who pays an employee what they consider to be a very high hourly rate with the intent or the thought process that that's already going to include the overtime premium, that the overtime premium is already baked in. That's going to create an issue as well. Or failing to include everything that's required in the regular rate calculation, such as bonuses or commissions. The other big bucket of issues we see are misclassification. That's both exempt status misclassification and independent contractor. We see exempt status misclassification issues arise where an employee maybe doesn't receive a sufficient salary, although that's pretty uncommon with the current salary level, which is set so low at $23,000. The new regulations or rules that we'll talk about a little bit may increase that, so we may see some additional issues with the salary level. We see issues arise where the employee is not actually paid a salary basis. So that's where there may be deductions made to a salary based on the quality or quantity of work, such that they're not actually paid a salary. It won't be considered won't meet the salary basis test. But the most common exempt status misclassification issues or cases turn on whether the primary duty performed is actually that of exempt work. We can move to the next slide. So, the question is what primary duty can be exempt. And, here we've listed some of the, the three most common exemptions under the FLSA and the definition or the bullet points for the primary duty that's required to be exempt under each. But the, kind of overall question of what is an employer's primary duty, under the FLSA, a primary duty is going to be the employee's primary, most important duty. Oftentimes that will be what they spend most of their time doing, but not always. And it's important to note that while the FLSA does not have a set percentage of time that must be spent on a duty in order to be considered the primary duty, several states do. Several states have, they must spend 50% or more of their time performing this particular duty in order to call it or consider it the primary duty. So when we look at these exemptions, the executive, professional, and administrative exemptions, what really ties and binds these exemptions together is that the role that these employees are playing for the employer should be something that's important to the business. It should, have the ability to steer the business or at least certain parts or divisions of the business, and an employee should be making or using high-level judgment, education, or creativity.
And one thing to keep in mind with the primary duty test for these exemptions, certainly they're important right now, or whenever it is that you as an employer are classifying employees as exempt or non-exempt. They become important again if, and for many employers, when you are sued by someone who says, you classified me as exempt, I should have been non-exempt based on my duties. In that event, what becomes really important is not just what we can say about the job, but also what we can show. On the one hand, you'll hear any attorney like Kara or I who represents employers say the job description, as an example, the written job description, just because it says some great exempt sounding stuff doesn't mean the employee is exempt. So that's certainly true. But what's also true at the same time is that sort of documentation can also be very helpful in the event of a lawsuit. When I think about a given position, let's say it's a payroll job or accounts receivable job or whatever the case may be, and we're looking at how it's classified, and we say, if there's a lawsuit on this job, what's going to be exhibits A, B, C, and D? Exhibit A is going to be the job description. Exhibit B, think about how do we communicate to employees and to the world what this job does? Job description is one of them. Performance evaluations would be one. Are we commending someone in their evaluation for how many people they called, for just doing volume, or are we commending them for, you really did a great job on this project where you impacted our business in a great way, here's how, that sort of thing. So performance evaluations are another big thing. And also, another thing to think about is compensation. Do we incentivize people, going back to the prior example, just to make calls? And do they get, some set amount of money for each call that they make, which might not really be an exempt type of work? Or are we comping them and offering them some sort of bonus structure for driving up profit, for doing things and making decisions that help to reduce expenses and increase revenues, those sorts of things that really would give us as the attorneys a way to say, look, this is an exempt job. Here's what they did. The job description supports that. The performance evaluations support that. And so too does the way that we paid them. We paid them, we incentivized them to do these exempt sounding things. Another thing I wanted to point out, if we could actually go back one slide, I'm sorry to do this. I'd hate to be that guy who flips backwards and forwards. So another thing to keep in mind that I just wanted to note on this slide. So we talked about the most common types of claims in the off the clock bucket, the regular rate of pay bucket, and the misclassification bucket. To focus on one from the regular rate bucket, I'd really think if I'm in an employer's shoes about the bonuses in the regular rate. For some reason, at least me personally, I've been seeing a lot of issues around this. Generally speaking, so the rule that you find in the regulations is that a non-discretionary bonus needs to be included in the regular rate of pay. Doesn't matter if it's a non-discretionary bonus paid each week, paid each month, or even paid on the year. It needs to be factored into the regular rate of pay on which overtime pay is calculated when it's paid. How to do that is that could be its own separate conversation, but the point is that it needs to hit the regular rate. What I'd emphasize there is that most bonuses for non-exempt employees are going to be non-discretionary. To be a discretionary bonus that's excluded from the regular rate of pay for overtime purposes, it is truly the type of bonus that is just a, hey, thank you, you did a great job, pat on the back. There's no expectation as to when it's paid, how much. If someone didn't get it, they wouldn't really have a valid way to be mad at you, that sort of thing. If those things aren't true, if someone knows, hey, around this time I get my bonus, or if I do this, I'm going to get about that much, you're really going to be in the non-discretionary bonus world, and you need to be thinking about how do I include that in overtime pay. On the salary basis one, under the misclassification bucket, one thing I wanted that I think is important to keep in mind is that certainly an improper deduction from someone's salary can render them non-exempt because the salary basis at that point no longer exists. But there's some case law out there that says even the threat of an improper deduction can be enough. And the theory there is that if someone knows, hey, if I take off this portion of time and if I do that, I'm not going to get paid my full salary, at that point, they're not really looking and feeling like a salaried employee. If they have to make the choice between either get my full salary or not under whatever the written policy is. The point there then is to really review the policies you have in place that speak to exempt employees about their salary and make sure that it doesn't even threaten. You don't have anything that can be construed as a threat of an impermissible deduction. So done with this slide, we can flash forward to, we can go one more. Okay, so we want to talk about why are we here? Why is it that Kara and I can focus almost, our entire practice is on wage hour issues. Why are there so many of these cases, and why has it been such a focus for employees, for employers, and probably most importantly, for plaintiffs' attorneys who bring lawsuits in this area? So go to the next slide. And this slide will illustrate something to you that you probably already know, but it will show it in a much more specific sort of way. This shows the federally filed lawsuits under the Fair Labor Standards Act over the past 15 years. And if we had 16 and 17, or not 17, but we had 2016 on here, you would see another increase. Kara and I, we're not statisticians, but we can look at this graph and we can tell you fairly confidently that the trend is going up, that if you look back to 2000, 2001, 2002, the number of cases filed under this law is quadrupled, you know, and it's stayed high over the last 5, 6, 7 years. We have arrows right there that you'll see pointing to 2004 and 2005. Depending on who you ask, you know, first of all, certainly you see a spike after that. And depending on who you ask, one reason for that would be that that was the last time of a major change to the FLSA. Particularly in 2003 and 2004, there was a change to the rules defining who can be exempt from overtime and who cannot. Generally speaking, when there's a change to the law, immediately thereafter, you'll see an increased number of lawsuits in that area is really plaintiffs' attorneys will scramble to find ways to either, number one, find employers who didn't get the memo and didn't adjust, or number two, to find gray areas of the law that haven't really been tested yet and create new claims out of that. So 2003, 2004, we had a change in the rules. 2005, 2006, and if you jump to 2007, you'll see this climb that's continued year after year. The cases are just surging, and it certainly continued. And the question is, why? And if we go to the next slide, we'll talk a little bit about that. So in our view, there's really 3 drivers of the surge in this area of the law. Probably the middle one is the most important, and it's the recovery for the attorney. You know, people ask, you know, who files lawsuits? One answer is the employees, but the real answer is that it's filed by the attorney who represents them. In this space, you have the FLSA, which is a fee-shifting statute. Basically means that if the plaintiff wins anything, if the employee recovers any amount of money where they could say that they're prevailing in that case, the attorney who brought the case recovers all of their fees. I've seen and read cases where the employee was shorted $1,000 over 2 years, 3 years, something like that, and they went to trial and they recovered $1,000, and the plaintiff's attorney recovered $150,000. It's not uncommon, and the statute says that that is possible under this area of the law. The other 2 buckets have to do with the employee. Number one, for FLSA cases, you have employees who can recover the wages that they were deprived, allegedly, over a 2 or 3 year period. They have to show a willful violation to get to 3 years, but willful is not really what it sounds like. Most people hear willful and they think, oh, it has to be, you know, we were in the back room and concocted a plan to deprive our employee of wages. That's not the case. Willful can certainly be also, you know, just failing to look at what the FLSA requires and failing to take reasonable measures to comply with the law. That can be a willful violation. In addition to the back wages that they weren't paid, allegedly, employees can also recover liquidated damages, which is essentially just an equal amount of the wages they weren't paid. If they were shorted $1,000 over 3 years, they can recover that $1,000 plus another $1,000 as liquidated damages. If you go to the third bucket, the recovery for a collective, this is a big area, a big driver too. This area of the law is easier than any area we practice in to bring a class or collective action. In other words, it's easy for an attorney who has an employee walk into their office and shows some colorable claim. I was shorted $1,000 because of, you know, I wasn't paid during my meal breaks, even though I worked them, or I wasn't paid when I was emailing all night at home, or I wasn't paid when I was on the road, whatever the case may be. Not only does a plaintiff's attorney look at that person as a claim, but unlike, for instance, let's say discrimination claim, which are highly individualized claims, typically you don't have a good class discrimination claim. Wage hour would be the exact opposite. Most plaintiff's attorneys assume that if they're paying one person this way, they're paying other people this way. And the law makes it really easy for them to bring that lawsuit for one person, but then to grow it to include many, many more people, even people they haven't spoken with yet. Beyond all of this, the real subtext for all of these drivers is what we talked about before. This is Depression-era legislation. It's not really been updated nearly as much as it could be or should be to a modern workplace. And as a result, there's a lot of opportunities for violations because of the greatness of the law, because of trying to interpret text that was really written for a different workplace in today's day and age. Next slide. Thanks. So we won't go into each settlement that's on here. What this is meant to impress is that these cases they're potentially costly is not a sufficient word. You can see the millions of dollars that these companies have paid in publicized settlements just from 2016. And these are numbers that I think if you had asked most people who practice in this space in 2008, in 2009, in 2010, are we going to still see these types of numbers in 2016? Most would have said, not sure, probably not. It's going to go away at some point. And it just hasn't. If anything, it's gotten worse and more prevalent. There are more and more attorneys out there who have brought claims like this and who are accustomed to bringing collective action claims and really using what skills they have to drive major settlements for employers like these that you see on this list. These cases that you're looking at here, they range from independent contractor cases where an employer, as part of their business model, had workers who they classified as 1099s bring claims that said, hey, we should have been W-2'd, and if we were W-2'd, we also should have been paid overtime and minimum wage, and we weren't. There's that. There's off-the-clock claims for folks bringing meal break and other off-the-clock type claims. And there's also misclassification claims represented on this list for folks like assistant managers who said, hey, they called us an assistant manager, they paid us a salary and treated us as exempt, but in reality, I was just a glorified hourly associate. That's really one of the key phrases we hear all the time, a glorified hourly associate, and I should have been paid like it. These settlements encompass all of those types of claims. Next slide, please.
And when you look at those numbers, it's not necessarily all that difficult to imagine why, that just supports the reason that these cases are so popular and are constantly drawing more and more plaintiff attorneys to this area. So it's probably not a shock to any of you. You're probably all very familiar with this, but the legal landscape and the FLSA landscape would be very different today based on new and proposed rules for the white-collar exemptions that were set to take effect December 1st. We had several, numerous roundtables and webinars that we had held and worked with clients sort of across the board in preparation for these new rules and regulations, or for the new rules, in preparation for that December 1st date. And then just November 22nd happened, and a federal court enjoined and put a halt to those rules. So many of you may have taken steps to look at your workforce to see if you needed to reclassify employees, to change salaries, and maybe even implemented a lot of those changes because the injunction did come down just days before the rules were set to take effect. We can go to the next slide. And the rules, the proposed rules that were enjoined would have really made some changes to what the current rules are. It would have more than doubled the salary, the minimum salary level that was required to classify an employee as exempt, and that would have made a big change in a lot of employers' workforce. And the change in the rules, was stated that the intent and the plan was that it would bring some 4 million employees who currently are classified as salary exempt, that it would convert them into hourly non-exempt employees and make them available to receive overtime pay. We can go to the next slide. So as we mentioned, the new rules have not taken effect, and it's sort of up in the air as to whether they will. There's a couple different challenges that are currently in place. Where there's the federal court challenge, where a court in Texas enjoined the rules days before that they would have taken effect. That decision is now on appeal to the Fifth Circuit. But the current administration's appointment or proposed appointment to the DOL has signaled that the DOL might not continue that challenge at the Fifth Circuit. There's also challenges that have been raised in Congress to delay or to change the rule. And then there's also potential challenges by the President Trump's administration. The president has issued a standing order for federal agencies to review what they consider to be burdensome rules before issuing new ones. This is something that might fall within that broad overview. And then, as I mentioned, President Trump's pick to head the Department of Labor has questioned the agency's authority to set the salary threshold. And you'll probably see some challenges there that the new administration could take steps to rewrite or unwind the rules. That would entail some, new rulemaking would probably take a while to go into effect. And the head of one of the country's most powerful labor unions has said that if there's any changes that are made to these rules by Trump's DOL, that he's going to file a lawsuit. So the status of these new rules is still up in the air. Regardless of what happens, pretty much everyone we're talking to and experts across the board agree that it's unlikely that the rules in their current form are going to stick, are going to take effect. What happens to them, we're not really sure. So stay tuned.
Yeah, and we've done webinars on this, and on some we've had in the past. I'd say that out of 20 questions, 18 would be, what's going to happen with the new rules, when will we know, and what's likely to happen. The when remains up in the air. Just this isn't legal advice, but just from having tracked this for so long, I personally would say that my hope and my expectation would be that we have some clarity within the next couple months. Most would expect the appointee for DOL Secretary, Alexander Acosta, to be confirmed sometime within the next few weeks. He certainly, at this point, has not had the same opposition as Andy Puzzer, who was the prior nominee who removed his name or withdrew his name from consideration. Once that person is in position, once if it's Mr. Acosta, things should start happening a little bit faster at that point, at least at the regulatory level. So certainly Mr. Acosta can't go to the Fifth Circuit and say you need to decide this appeal faster, or to the case that's still left in the district court challenging the rules. But to Kara's point, certainly he could impact whether the DOL continues to take the positions it has in the litigation. In addition, he could commence new rulemaking. He doesn't have the ability to take the rules that are in place right now and say, hey, we're going to strike out $47,000 and make it $35,000. But what he can do is commence new rulemaking, just like they had for the rule that got to $47,000, and say, we are going to consider instead $35,000, something between $23,000 and $47,000. If I was a betting man, that'd be my bet. But I hope no one takes that to mean that I have knowledge that that's what is going to happen, because I don't. But that would be my expectation, which I think is fairly reasonable. One thing to keep in mind through all of this is that for a while, most employers rightly assumed that whatever states were doing with the salary levels under their state law exemptions didn't really matter, because $47,000 was going to be higher than anywhere, higher than California, higher than New York. And so if employers had to comply with $47,000, then they would have been complying with the state law salary requirement anyway. With $47,000 on hold, that's no longer the case. California is certainly higher than the federal level at this point in time, which is $23,000. Also higher than $23,000 is New York. New York City just released its updated salary requirements, I believe, in January of this year. And I want to say that for a large employer in New York City, it's either 38 or 42, somewhere around there. But if you're an employer in New York, especially in New York City, it is imperative to make sure that you take a note of what the new requirements are in that state, and that you're abiding by them for your exempt employees there. Again, that would be something you wouldn't have had to really worry about if the new federal requirement had gone into place. But now that it's on hold, it's a different ballgame. Next slide. Okay, so we want to talk, and we've kind of already woven some of this in, but we want to talk about what this slide suggests. So the FLSA is an area where, unfortunately, it's easy to have violations, even for employers that are aware of the law and take efforts or make diligent efforts to comply. So go to the next slide. And we want to talk about some of the common mistakes we see with exempt classification in particular. That's one of those buckets that Kara mentioned earlier in the presentation. One common mistake that we see is, let me step back from this even before we go into the buckets. One of the most common mistakes we see, especially for employers who don't know the FLSA that well, which wouldn't be you guys, but it's just worth mentioning anyways, is the belief that, oh, we pay them a salary so they're good. And that's usually when I march out my example that, you know, you could have a janitor making $90,000 a year, and that person is not exempt because they don't have the right duties, even if they have a sufficient salary. Likewise, you could have a CEO who is earning, you know, $25,000 a year as a salary and maybe takes the rest in some other form. And that person might not be exempt because they don't have a sufficient salary, right? I shouldn't have said 25, I should have said 22. But you get the point that you have to have the duties and the salary both at the same time. In addition, so we'll go into some of the more nitty-gritty stuff in these buckets. One mistake that we see a lot is the belief that, oh, well, you know, it's an office worker. They're not on the line. They're back here in the office doing, you know, office type things, and so they must be exempt if we pay them a salary. This really brings into the fold the administrative exemption, which is one of these core exemptions that we talk about in the FLSA. And certainly the administrative exemption can apply to office type work. That's typically what that exemption envisions. But it really has to be folks who are making decisions, or at least, you know, directly impacting decisions that influence the direction of the company, of their division, of their unit, as opposed to just, you know, being the person who delivers information to the person who then makes a decision, that sort of thing. We want someone who's involved in the decision making and for whom we could say, you know, look at something and say, this is their impact on the business. Another thing that we see a lot is, well, hey, you know, they're a manager. They're over these other people. You know, they're senior to these 4 people, and so they're exempt. They're good to go. And what we're talking about here typically is going to be the executive exemption. The executive exemption, as most of you know, will be someone who is has authority to hire or fire employees, or is at least heavily involved in those decisions. Someone whose main duty is to manage a department or a division of the business, and someone who also directs the work of at least 2 full-time employees. What we see in this area sometimes is, number one, folks who don't really direct 2 or more full-time employees. Maybe they are like an intermediary manager, you know, maybe it's like a team lead or something like that, who doesn't really direct the work. Instead, there's a manager above them who directs the whole team, including the team lead. Another thing we'll see is insufficient involvement or authority in hiring and firing. By no means does this exemption, the executive exemption, require that we allow people to go around and hire or fire people at will. As you all know, from an HR perspective, that would in fact be a bad idea. But they do have to have authority that we can really show in a lawsuit, you know, that would demonstrate that they are involved in these decisions. You know, they interview employees, or they make the final decision on who should be hired after we go through whatever process it is that we have in place to properly screen candidates. Or for a termination, they make termination recommendations within our given policy, and those recommendations are typically followed. You know, they don't go just into a, you know, the suggestion bin that never gets checked, that sort of thing. And then,
jump in.
Yeah.
You'll see on the slide here, you know, we referenced this one-hand test, and that's, you know, as Kevin mentioned, the executive exemption has a baseline requirement that they direct or supervise 2 or more full-time employees. And what I like to refer to when I talk to an employee, or when I talk to employers, is if they're describing a position to me and they say they supervise 2, 3, 4 full-time employees, yes, that meets that first, you know, requirement for the executive exemption, but it causes me to question, you know, if you're supervising, you know, 5 or less employees, is your primary duty really management? Are you really spending the sufficient amount of time, and are we placing the importance on the actual management duties? And that's where that one-hand test comes into, and sometimes that's yes, but the answer is yes, absolutely. But that's just one to sort of pay a little bit more attention to management roles, or to people we've classified under the executive exemption who maybe don't supervise all that many employees.
That's a great point. And one other area, this is the last bucket you'll see here. So the computer, we see it a lot where, a client will say, well, they work with computers, they're a computer analyst or something like that, or a help desk person. And I know there's an exemption for computer employees, so they're exempt under that. And there again is a trap, because the computer employee exemption, like the others, is quite narrow. And it really has to do, that's folks who impact, what does our software do? What types of systems are we actually going to put into place? Or, rewriting the code, that sort of thing that we have. It's developers, designers, high-level systems analysts. It's not going to be a help desk employee, 4 out of 5 times. I tell some employers, if something they do on a regular basis is to tell someone to restart their machine, typically it's not going to be, rising to the level. Their work is not going to be rising to the level of an exempt computer employee. Another thing on this computer exemption too is that some states don't have this exemption. I believe Connecticut is an example I looked at just last week. There's no computer exemption in that state. So you could have an employee who is in that state who's an exempt computer employee under the FLSA, but under Connecticut's wage and hour law and their overtime law, you'd need to find another exemption, or else they'd be entitled to overtime pay. All of this stuff, if you have questions on it, certainly makes sense to think about, which jobs need review, and then to set some sort of plan for reviewing those jobs and making sure that you have good classification decisions around them. And that sort of decision-making process will nearly always make sense to go through with an attorney, if only to ensure attorney-client privilege around that sort of analysis, where you really go through and give a hard, sober look at whether a certain job should be exempt or not. In addition, hopefully it'd be an attorney who's knowledgeable in this area of the law and would be able to look at a given job and say, okay, well, here's some risky, areas of that job. Let's look at those areas, that sort of thing. Let's go to the next slide. A big risk that we've been talking to employers about a lot, and this is something that I would say goes into the bucket of things that keep me up at night a little bit, is employees who employers go through their analysis. They say, okay, we're reassessing this job. It was exempt before, but its duties have changed, or our understanding of the law has kind of evolved, and now we're going to make them non-exempt. We're going to reclassify them. That's a good thing. That's a good step one. They've gone through that analysis and said, okay, we need to flip them. What keeps me up at night is the after that. So certainly, in communicating those decisions, there's all sorts of things that need to go into that decision. How are we going to communicate it to them? Who's going to answer their questions? All of that sort of stuff. When they ask why, what's our answer going to be? But even once we get past that, I think there's a lot of risk down the line. And the risk would be, if for any exempt employee, if you put yourself in the shoes of an employee who's split. For me, if someone told me, hey, Kevin, as an attorney, you're going to come in on Monday and you're going to be non-exempt, would my practices really change? Would I stop emailing with my colleagues late at night, or emailing clients on the weekend or in the morning, or what have you? All these sorts of things that are just minefields for non-exempt employees if they're not dealt with appropriately. If you have an employee who's flipped and just keeps doing what they're doing and doesn't really view the timekeeping as an important thing for them, it's just sort of a formality of the job, then you are sitting on a pile of risk for if and when that employee either one, is terminated, or just the relationship sours, or two, another employee has a relationship that sours, they bring a lawsuit and they file a collective action, and this person ends up being a part of it. So one thing I really have been advising as many folks who will listen as possible is, for the employees who you flip over, it's not just important to get that classification decision right. It's important to think about, how does their experience need to change? Part of it is training them about timekeeping, and part of training them about when can you work, what do we expect, that sort of thing. Just as important is training their managers. Training the manager who might not have overseen non-exempt labor before, that if you're getting emails at 9 p.m. and their time cards show that they're clocking out at 6 p.m., you've got to be able to recognize that. And you've got to be able to coach that and deal with it in a way that fits the company policy. I think that covers most of what's on this slide. Another thing or two more things I'd mention, just in terms of tips for avoiding off-the-clock type claims. So one, again, the big one for me are the employees who are being flipped. Another one that I talk to clients about a lot is what I call the rule of repeating 8. And I don't think I made that up. It might just be circulated around Seyfarth for a while. But managers should know that employees don't work 8.0 every day of the week. It's not, unless you're on a line type job where you're doing gang shifts where everyone starts and stops at the same time. It's not something that you expect to see. And we see a lot, especially where employees enter their own time and they just put down 8 and they say, well, I'm expected to work 8 and it felt like 8, so it's 8. When I'm on the defending side, if an employee files a suit, says I was not paid for work I performed off the clock, and one of the first requests that we'll make is to the employer, hey, can we see the time records? If we see that 8.0 come in, you just cringe. You just know it's going to be an exhibit that, number one, is coming out. It's going to be one of the central parts of the lawsuit. And number two, it can be really hard to explain. Time records should look like hours worked. If you have an employee who sometimes comes in a little bit before shift and gets going before 9 a.m., then time records should reflect that. And same thing on the back end, and same thing for employees who work on the road, that sort of thing. Another thing, or two other areas that I caution employers to look out for. Number one are timekeeping edits. Most of the time, if you have a time record that can be edited after the fact, there's some audit trail of that. This is a double-edged sword. On the one hand, you want employees with their supervisors to be able to edit their time records to make sure that they're paid for all hours worked. Hey, I forgot to clock out. Or, after I went home last night, I worked 30 more minutes, it needs to be logged. So you want to have that process in place. At the same time, you want to make sure that you're checking the audit trails to catch that bad apple supervisor, if they exist, who's maybe editing records, to make their labor budget look a little bit better. It doesn't happen a lot, but when it does, it's the kind of lawsuit that you just have to almost settle immediately and hope it doesn't get out. The last thing on this, if you're an employer who's considering whether to have a verification process for employees, some way where either by a click or a signature or whatever the case may be, they verify on some regular basis the time they're submitting is accurate. I haven't found a situation where that's a bad idea yet. It's really nice in a lawsuit to be able to say to an employee who's saying, hey, I worked off the clock, to slide time record after time record across the desk and say, you verified on this date that all of the time that you submitted was accurate, that it's complete, that everything's in there. That's your signature, or you clicked that, right? Right. Next record, so on and so forth. And it really is a nice thing to have. It's not just because it's good in the lawsuit, but also because it can impress to employees that this is a really important thing that they do, and we want to make sure that we pay them for every minute that they work. Next slide, please.
So speaking of paying employees for every minute they work and common mistakes for off the clock work, we see and we tend to hear a lot that well, it's not employee work time because it wasn't scheduled or it wasn't approved or I didn't ask for it, or even at some times I saw them doing it, I knew they were doing it, but I specifically told them not to, or overtime needs to be approved, I didn't ask for it, I didn't approve it. Long story short, none of these are really good excuses to not pay the employee for their actual time worked. As a sort of across-the-board rule, if you as an employer know, or you should have known, that the work was performed, you have to pay it. There's really just no excuse not to pay for the hours worked. Now, all is not lost. That if you, what you can do is, first off, have policies in place that, specifically state that off-the-clock work is prohibited, and train your managers and your employees to impress on them the importance of getting paid for their actual hours worked. And then, if you come to the realization, or if you know that an employee is working and not clocked in and getting paid for that time, pay them for it. But then on a going forward basis, just like you would for any other performance issues or tardiness, you can counsel them. You can, retrain or, re-impress upon them the policies to hopefully avoid that moving forward in the future. Let's go to the next slide. Another common mistake that we tend to see is not including all the required time in the calculation of hours worked. So, for example, the computer boot up, donning and doffing. The question is this activity that the employee is performing what's called integral and indispensable to the employee's principal work activity? So, is the activity one that the employee can't get rid of, can't not do if he's going to be performing his or her principal activities, the reason that we have them employed or the main activities of their work? If so, you have to pay for it and include it in the calculation of their hours worked. Go to the next slide.
Yeah, so we'll go through these next two slides pretty quickly. The first one, meal and rest breaks, just simply stated, the FLSA doesn't require that employers provide a meal break. Where employers get into trouble here is where they deduct time taken for meal breaks that weren't actually taken, either because they were interrupted or cut short, or just because they weren't taken at all. We see a lot of employers nowadays who have or are considering auto-deduct policies, where we're going to automatically deduct 30 minutes because that's what we expect you to take for a meal. If an employer has that, then it becomes especially important in that case to have robust training and policies in place for what an employee should do if they don't take that 30-minute meal break, either because they don't take it at all or because it's cut short or interrupted. When we're talking about a 30-minute meal break under the FLSA, 30 minutes that can be actually deducted from the time worked, we're talking about 30 minutes of continuous time. So it's not 17 here, then an interruption, then 13 more later. It's 30 minutes of continuous time. It's uninterrupted, where the employee is completely relieved from work. They're not talking to their supervisor about work. They're not getting instructions about what they're supposed to do when they come back. It is really their time. And so that's just one of the things to keep in mind, that if we're deducting meal break time, that we're training our managers and our employees about what a meal break is supposed to look like. We can go to the next slide. This one, there's really not much to say on this one that's not on the slide. Meeting time, training time, similar activities. This sort of stuff, as a general rule, is going to be counted as work time unless all of these conditions on the slide are met. It's outside the employee's regular hours. It is purely voluntary. Whether to attend, they won't be reprimanded or even thought less of if they don't go. It's not directly related to their job. And of course, this last one is obvious, that they're not performing work during the attendance. If it's mandatory, if it's directly related to the job, if it's during working hours, then it should be paid time. We can go to the next slide. The next slide, again, we have the rules here, so I'm going to just run through them. But one thing I want to impress on travel time is that this is an area where state laws can deviate fairly significantly, particularly on the overnight travel, which is the last sub-bullet under the first bullet. So it's important to keep in mind, where are you operating and do the states differ on the treatment of travel time. Ordinary home to work travel, your normal commute in and out each day, not compensable. Once you start the day, once you have your first, once you get to work and get going, travel within the day, going from site to site, that is compensable, that's paid time. Same thing with travel time for a one-day assignment in another city. That's going to be paid time. The one place where the FLSA is a little bit wonky is this last sub-bullet that I mentioned before, travel that keeps the employee away from home overnight. If it cuts across their normal working hours, if they work 9 to 5, then then any travel for an overnight trip between the hours of 9 and 5 should be paid under the FLSA. Outside of those hours under the FLSA need not be paid. It doesn't matter what the workday is. So as an example, if someone's normal is 9 to 5 Monday through Friday, and they travel between 9 and 5 on Sunday, it should be paid time. Even though Sunday is not a day that they typically work, the way that the rule is written is that if it's during normal working hours, regardless of the day, it should be paid. This is an area where state laws differ. Some states, California is one of them, but it's not the only one, say that if you require travel of this variety, then it needs to be paid. It doesn't matter when it was, if it's 9 o'clock, 10 o'clock, 7 o'clock, whatever the case may be. If you're required to travel, then it needs to be paid. can go to the next slide.
So we've been talking a lot about, overtime and for non-exempt employees, and when we talk about the overtime premium, we talk about it in the way of, 1.5 times or 1.5 times the employee's regular rate. So the regular rate is calculated as an hourly rate, but the calculation to get to the regular rate includes more than just that employee's, the actual hourly rate. Generally, to calculate the regular rate is total compensation for the week for their hours worked, divided by their total hours worked. Regular rate includes all their pay, shift or weekend differentials, and as we talked about earlier, bonuses unless they're truly non-discretionary, which I think both Kevin and I agree is really uncommon. Somebody recently referred to it as, a unicorn if you see a truly completely discretionary bonus. We'll go to the next slide. So this is, we identified this as sort of a big bucket with the misclassification and independent contractor cases are cases that we're seeing more and more of. They're more frequent, and the potential exposure to employers is very high. Often people that are classified as independent contractors are well paid and may work a lot of hours in a given week. So once you calculate the regular rate and have to pay them an overtime premium, we're talking about potential high dollar cases here.
Yeah, and the key here too, for independent contractors, it's not much. It's a similar way of thinking with exempt employees, namely that the rule generally is going to be that it's an employee. For the exempt calculus, the rule is generally it's non-exempt unless you know that you've got the information to treat them as exempt. In other words, it's the employer's burden to prove it. Very similar with independent contractors. I mean, especially the way that these cases have been unfolding, you've got to have a good case to call someone at 1099. And generally speaking, if a court can find a way to treat them as an employee, they're going to. So it's really important to assess those relationships. It's not the key driver of this sort of calculus, but time is a big one. Independent contractors, they're not sticking around continuously for 5 years. And I realize that's kind of going to one end of the spectrum, but those sorts of considerations, what are we asking them to do? How long have they been with us? How much do they look like our employees? Do they do the same thing that we have, Tom down the hall doing the exact same thing, except he's a W-2 and this person's a 1099? All those sorts of things are really important. And they get back to what Kara is getting at, which is assessing those relationships to see, if they were challenged, would they have a claim that they should have been treated differently? Because if so, to Kara's point, not only do you have a potential minimum wage and overtime claim, you also have potential tax issues. Something the IRS has been a lot more interested in because it has to do with proper or improper withholdings and things like that. Yeah. We can go to the next slide, and I think that completes the substance of what we had planned to speak about.
Great. Thank you, Kevin and Kara, very much. Very informative and a lot of different things you have to remember, and obviously keep referring back to as it gets pretty tricky with both federal and state and municipality rules. So thank you very much. Very enlightening. We're now going to move over and talk a little bit about how you can use a good time and labor system really to try to address some of these issues, and how you can pull out that information of what's happening and use analytics to really look at what is the root cause of some of your biggest compliance issues. I'm sure a lot of you are now thinking, holy cow, there's a lot of things I have to watch, a lot of things I have to make sure. Yeah, if it's all manually and you're doing it by paper and pen or an antiquated system, you probably should be pretty overwhelmed and frustrated. You might be thinking, am I properly compensating employees for off-the-clock work, such as travel time? If I'm not, well, how do I go about and do that? Or, yeah, I think I am, but how do I make sure I'm doing it? How do I audit that? How do I look for discrepancies? Are my employees taking state-required meal breaks? Am I following that? Can I get some analysis on that? Where am I exposed? And then overtime, they talked a lot about overtime in terms of it being calculated correctly, including the right things. How am I doing that? So I'm going to introduce Jay now, and have Jay join us, and he's going to take you through some cases and and some examples of how we help clients answer these questions. Jay?
Thank you very much, everyone. As Michelle described, the objective of analytics is to find meaningful patterns and knowledge in your data. Can you go to the next slide, please? So what we have found is, and this has been 3 years of research that we have done in this area, is that essentially with these set of data sets, you can pretty much answer almost any question or any report that you want to have out of your data. And this type of data set can really help you mitigate risk and create competitive advantage for your organization. So the data sets the first 4 are pretty obvious. They are punches, there are audits, which are any change that has been done to original data. Timesheet is the calculated time out of your punches, and budget and schedules, which you can use for understanding whether you have, you're over budget or attendance and tardiness and those things. Now, out of those 4 sets of data, we create another 4 sets of more detailed outcomes. First one, we call them open punches. These are a list of punches where the in, out, or both in and out have been closed by somebody other than the employee. So the employee forgot to punch out and somebody entered it, or basically a manager went in and entered the whole time for the employee. Time changed are any punch where the original in and out has been modified to something other than the employee's value. So employee enters 9 to 10 and manager changes from 9 to 11 or so forth. Obviously, the open punches and time change punches are mutually exclusive, because if you had the in and out in the beginning, then it would be considered time change. And the next one is what we call miss punches. There's a bunch of validation logic around when people punching in. Validation may be around, for example, facial recognition or fingerprint or GPS fencing, things that say, you want to, if you use, for example, a mobile app, you want to make sure the employee is not staying at home pretending to be at work. So we have this thing called GPS fencing that says, okay, we're going to only, any punch that is not within verified radius of your location has to be approved. There may be other reasons for it. Like, for example, schedule. You are coming out of schedule and somebody has to accept it. Now, in our system, we never, ever block somebody from punching in. But if there's some additional verification is required, we highlight it as mispunch, which requires additional verification. The last one is what we call correction lag. This is essentially the time between when the exception happened and when it was corrected and by whom it was corrected. And surprisingly, of all the things we can measure, it happens to be the most impactful driver. Because think about it, if you don't make corrections quickly, then you have to do it at the end of the cycle. So when you come to payroll page, you now have to remember where the employee worked 2 weeks ago, or why was the reason for any changes that they have requested. But if you stop the bad data from propagating from the onset, then you would get essentially a lot less noise downstream. So we have seen, just by visualizing, by measuring and tracking correction lag, we've seen like orders of magnitude improvement in productivity and the risk mitigation. Things around 100-fold reduction in the retro check. Or, think about every correction may take 2 or 3 minutes to do. If you reduce it by 50%, you have now thousands of hours of labor productivity for your managers that can be used for other things besides just doing mundane time entries and corrections. So those are the views that based on those views, we have been able to build all sorts of analysis and results. So I'm going to quickly go through a couple of analyses. Next slide, please. So it's very common, if you can go to next slide, please, to get a request from the Department of Labor to say, show me you paid people correctly for past 3 years. I mean, this is a daunting question. Well, if you have the data, it's not. We simply, this is an actual example with somewhere around 8 million records that had to be, verified. So we basically looked at the original punches. We looked at the timesheet and found out the population where there was a mismatch between what they actually entered and what was paid to them. Then we went to the audit reports and looked at audits, because every time you do an audit, we have something called reason codes. We can explain why the change has been happened. And it turned out the majority of the changes was because the employee didn't take the meal break and manager entered it. So, there was explanation for all the changes, and it was easy to do. It literally takes us only 2 days to get this analysis done. And then from that, we created that obviously became, obvious that, that the people should be entering their own lunches. And that transitioned to putting meal break alerts where it enforces the policy to their employees. Next slide, please. Now, we have a client that says, look, I have all these different things I want to measure. How do I make sure I have one thing to track rather than have to track 18 different things? So we came up with the idea of something like a GPA. We take all these different drivers and we categorize them. So if you have open punches less than 10%, we said, okay, you're A. Between 10 to 30%, you're B. So you kind of put the category, A, B, C, D category for each one of the drivers, and then you put a weight on what's more important, and you come up with a GPA between basically 0 to 4. And now you start ranking your employees, you're ranking your job site, you're ranking your manager based on that GPA. And it has been, again, really transformative, because you can now easily see where are the best practices, where are the worst practices. An interesting thing about this is when we're finding there's too many touches to the data, it's not necessarily a nefarious thing. It's not like people are intentionally doing it. It's typically either a poor training or poor setup. So it really lives to the continuous improvement. And obviously, again, as I said, if you don't touch it, if you track it accurately from the onset, then it mitigate a lot of the risk downstream, so you don't have to worry about it later on. Next slide, please. So what we have is we have also ability to take this data and provide the clients with a custom view of them. And this, there's a bunch of standard objects, but there's also can be customized to anything you want. So this data can be presented to different layer of a management, to the store employee all the way to the executives, where they can see their portion of the data, they can see their related data graphs, and they can click on this thing and they have an automatic drill down. So this is the way we can essentially put together a very customized dashboard for the clients. Next slide, please. And the kind of things we do is, I'm listing mainly here TLM type of things, productivity, attendance, overtime, or ratio of the people who earn benefits, but they don't have any labor in the system. But it can be all sorts of things. We have benchmarking information, geographical benchmarking. We have what's called vital signs, which are like the turnover rates, productivity, payroll accuracy, and we have things we call them insights, like correlation between compensation. And there's also stuff, as I mentioned, the objective here is to be able to find meaningful patterns and knowledge and leverage that to improve your productivity and mitigate risk. Next slide, please. So this data, again, is get delivered to a different part of your workflow, so we can stop the bad data from propagating. I call it QA 101. You let people know what is the right decision they have to make. You make them you provide employee with alerts around tardiness and different aspects. But the point is, it's a very effective way to take that knowledge and make it what we call actionable intelligence that will improve your workflows. Next slide, please. And that was essentially that's the full cycle now. With the knowledge that we have gained, ability to deliver that information to the different part of your organization, you can now truly have a continuously improving process. And this has been extremely effective, and we have seen tremendous amount of productivity and improvement for our clients, and it has become actually a competitive advantage tool for them. Thank you very, very much for your time. I've just covered the items I wanted to go over today. Thank you.
And thank you, Jay. All right, it looks like we have about 13, 14 minutes to answer some questions. So I'm going to turn it back to Kevin and Kara, because I'm assuming most of those questions are for them. There's a lot out there, so obviously we can't get to all of them, but I'll turn it back to you guys to see if you can answer some of those questions.
Sure, this is Kara. Actually, Kevin had to run. He had an emergency with a client issue that he had to address. But I certainly can go through these, or some of them. The other thought would be is, if we wanted to sort of answer them offline and provide those a little more detailed responses, we could do that as well.
Okay, well, let's see if there's a couple there that might make sense that the whole audience would like to hear today.
Okay. One of the questions was about some of the settlement slides specifically, about those really high dollar private settlements, about what was the subject matter of those lawsuits, and how much do the employees actually get from some of these major settlements. I can tell you, without getting into too much detail or taking too much time, that the first two were both with FedEx, and they were the highest, by a large margin, $240 million and $226 million. Both of those were independent contractor misclassification cases for drivers. We've seen lawsuits like that pop up across the country with a variety of companies. The first one, the largest one, $240 million, was a nationwide collective action under the FLSA with 12,000 drivers across 20 states. Misclassification, independent contractor, which then claimed that they were deprived of overtime wages, reimbursements for expenses, and benefits. And then the second one was California, California specific, in a class action. And in general, when we talked about how popular these cases are, and that a lot of times they're really attorney driven, it varies, lawsuit to lawsuit and really case by case, but part of the FLSA, the purpose of the FLSA was to provide employees the opportunity to pursue claims that are maybe small and so small that they would not otherwise on their own pursue independently, so they can join together and have this collective action. So you might have hundreds or thousands of employees, each of whom have claims that are worth a couple $100 or a couple $1,000, but when joined together, that creates a lot of potential liability. But what it also does is create the opportunity for attorneys who are representing these employees kind of across the board to have, fee agreements set up where if there's settlement, the plaintiff's that attorney might get 30 to 40% of the total settlement. So the employees oftentimes, or the employees are really only going to recover their individual alleged back pay or unpaid overtime, plus liquidated damages. And it's the attorneys who are really going to get the larger cut oftentimes of these settlements, which, sort of ropes back into or ties back into the popularity of these lawsuits. A lot of these do get a little bit into some advice and counsel. One of the questions was, can you have an employee or two employees who perform the same job or the same role? Can you classify them or treat them differently for FLSA purposes? As a general matter, I guess at most basic level, the answer would probably be yes. You're really going to look at, the individual duties and responsibilities. What we tend to see most of the time, you can challenge the exempt status classification when you classify an employee as exempt or as salary. There's not really much you can challenge other than, off the clock work, or, improper calculation of regular rate and overtime. You can't, there's no claim or there's no challenge that I was paid hourly and should have been paid salary. So that's not a type of claim we would see. So I'm not really sure, the purposes behind why an employee, two employees who perform the same job or the same duties would be classified differently. I suppose in theory you could, assuming that the employee, the job duties actually being performed in the salary level meets all the requirements under the FLSA, but for whatever reason you choose to pay one employee hourly versus the other salary. That being said, that might, be used as evidence in a lawsuit about, against the exempt status classification to show, look, they've made the determination that this is actually a non-exempt role, and look, this is an example of that. They're paying this person hourly and classified as non-exempt.
Can I also answer, there was a question about ability to provide notification to employees around meal break. I just want to say that that's absolutely a very, very common feature for our system. There is actually 4 different types of meal break analysis or notification. One is that missing meal break. The other one is that too short, too long, and the 4th one is essentially too late. They took it like at the end of the pay cycle, more than whatever 8 hours that was a trigger limit. So those things actually are tracked on our system automatically with or without the alert setup. It's even if you don't stop alert, we're still tracking that information. But then you can obviously turn on the alert, which can go to the employee or their management, however you want it to do. But in California, obviously, that's a very, very critical issue. There's also a lot more I can explain about the different approaches to handle meal break collection challenges, but that was just want to cover that question for now.
Great, thank you, Jay. Anything else, Kara, that you see that you could answer now?
I think a lot of these are a little more detailed or context specific. And we're more than, and I think I posted our contact information. We're certainly more than happy to answer these questions, to circulate them, and to answer to the extent we can.
Great. Well, I want to wrap it up then and thank Kara, you and Kevin for joining us today, and Jay also. Fantastic information, and I hope everyone on the line today was able to learn a few points and be able to take that back to your colleagues and coworkers. At EPAY Systems, we would love to be your human capital management provider and also help you address time and labor management, specifically some of those requirements that are needed to be able to handle some of the situations that we talked about today. Jay is always available, so for those of you that might want to talk a little bit more and understand some of the things he was addressing, just let us know and at the survey at the end, and we'd be happy to schedule something. All right, thank you again very much for your time.
Well, I want to thank all of our presenters today and EPAY Systems. Just a few reminders for the attendees. If you would like to view this webcast again, the archive recording will be available on site for up to 7 days. The slides are also available to download. Your webcast credits are stored in your HR.com account. Watch for your email to arrive within 1 to 2 business days. It will contain the certification credit information. Your feedback is important to us. Please take a moment and fill out the exit survey that will appear on your screen. This concludes today's webcast. Have a great day.